I'm going to focus on limited parts of it. Well, by the way, if you haven't learned this technique yet, when you're in the middle of a document, whether it's my PowerPoint, whether it's a website, whether it's a PDF file or a Microsoft Word file, Control F. Control F is going to bring up a dialog box, and you put in certain characters, and it's going to go look through that entire document for that string of characters. So if you're looking for lease with an option and you put in those words, it's going to go look for that series of characters and pull it up every place it finds it. Okay, now it applies only to a contract for the sale of real property that's used or to be used as the purchaser's residence. So none of this applies to commercial property, only to somebody who's going to use the property as their residence. This is why it doesn't apply to you as an investor when you're trying to enter into a lease with a seller. It doesn't limit your ability to enter into a contract for deed with the seller because you're not presumably going to occupy this property as your primary residence. Well, having said that, maybe you do. Maybe you will begin after tonight to understand the power of this particular statute. You may decide you want to go out and find some seller out there who's going to enter into a lease with an option with you, or is going to enter into a contract for deed with you, and you're going to hold the trump card that you could play at any time because they're in violation of the statute. Now, I'm not suggesting that you do that, but it's a possibility. And it happens on a regular basis that people who understand the statute are out there looking for people who don't understand the statute. Okay? Now, it also applies if it's the residence of somebody who's related to the buyer, but that's another matter. It's not as important. Okay. If it's a lot measuring less than an acre, it's presumed to be residential property. Now, a lot, if it's going to be used in the future as somebody's residence, is also going to be affected by this statute. It's if the property is used or is intended to be used as the purchaser's residence. And if you want to make sure when you're dealing with somebody that they're not telling you it's going to be investment property and then are going to turn around and move into it, you might want to get an affidavit from them, some kind of a representation that they're buying it as an investment and are not intending it to use it as their residence, so you don't get stuck being affected by the statute. Now, here's the critical part with a lease with an option. It's called Section A2, and from this point forward, the statute's going to make reference to an A2, and an A2 is an option to purchase real property that includes or is combined or executed concurrently with a residential lease together with the lease. It's considered an executory contract, but it's described as an A2 executory contract. It doesn't apply, this is very, very important. This statute does not apply to any contract that provides for the delivery of a deed from the seller to the purchaser within 180 days. Now, let me tell you what this statute's all about. This statute is all about the state legislature coming to the conclusion that there are people out there taking advantage of consumers who think they're buying property or think that they're accruing the rights to buy property that they're going to occupy as their residence, only to find that those people don't end up giving them a deed or don't end up making that good on their contract. And so what the state legislature has done by this statute is essentially to require investors who are dealing with this kind of consumer to effectively enter into a contract that's going to provide for the delivery of a deed in 180 days. So do not go out there and enter into a residential contract with somebody for longer than 180 days. If it doesn't provide for closing in 180 days, theoretically this statute is affecting you. And don't enter into a contract where you're going to be coy and close the transaction and do everything that has to be done except give the seller a deed. I just recently settled a case where I represented some buyers who bought a property back in 2009, and when they bought that property back in 2009, they closed through a title company, and a lawyer's law firm handled the transaction. The seller didn't give my client a deed. The contract that he signed up said he wasn't going to get a deed till he finished paying off the purchase price of the property. And here it is in 2012, we sued the seller, we sued the title company and the law firm that handled the transaction. I'm not allowed to discuss the settlement terms, but the bottom line is you got a problem if you're entering into a transaction in which you're not providing for a delivery of a deed in 180 days. Now, the statute breaks up situations between 180 days. Virtually anything goes within 180 days. You can enter into a lease coupled with an option. You can sign a contract for the sale of property that's going to provide for the delivery of a deed in 180 days. But then it breaks it up into another part, which is whether the lease term is 3 years or less. And then there goes another breakup of the statutes that 3 years or more. And there's a small window that you can theoretically jump through. You're going to see there's not much of a window to jump through, but at least there's a theoretical possibility that you can jump through that window if the lease is coupled with an option of less than 3 years. More than 3 years, and you're back to the main effect of the contract for deed statute. And let me just get to the bottom line very quickly, because again, we're going to likely run out of time. If you violate the contract for deed statute, the primary remedy for the tenant optionee or for the buyer who doesn't get a deed is that they have a legal right to get all of their money back, including the value of the improvements they've made to the property during the period of time that they've been in there. You think about that for a minute. Do you want to take the risk of having a legal right, creating a legal right that enables your tenant or your buyer who may have been in there in your property for years and years to have the right to come back and get all of that money back from you? You don't want to be in that position. So you don't want to enter into a lease coupled with an option without complying with the statute. You don't want to enter into a contract for deed without complying with the statute. There's another remedy that's even more draconian. If you enter into a straight contract for deed or a lease of more than 3 years, now you've got an even bigger problem. By January the 31st of every calendar year, well, of every year, you are required to give the seller or the tenant optionee a report. It's about 7 pieces of information. And if you don't provide this report by January 31st, there's a penalty, liquidated damages according to the statute, of $250 per day. I once represented a buyer who had entered into a contract for deed, and the out-of-state investors who'd sold my client the property had taken her money for 3 or 4 years, including her down payment, and then they had, my client was in default, they canceled her contract, they moved to evict her, and she came to see me as a lawyer to help her with the eviction. And I recognized that they violated the contract for deed, the executory contract statute. I ended up owning their house. It was owned free and clear by them, but my client and I ended up owning their house. Why? Because she didn't make a report to us by January the 31st. $250 a day in 4 days, that's $1,000. In 40 days, that's $10,000. She hadn't made a report, they hadn't made a report to her in several years. So when we sued them, they had no problem in deciding that they weren't going to win that lawsuit, and they just deeded the property over to us. I had a 28% contingency in the property, and that's how I came to represent her. There are other lawyers who are out there like I am that will take that kind of case, and that's why you don't want to be entering into a contract for deed or an executory contract or a lease coupled with an option. But if you do have a contract, a lease of 3 years or less, then there are 4 different kinds of sections that apply. I'm going to race through these because that's not that critical. But here's the biggest problem. You can't enter into an agreement to do a lease coupled with an option unless you own the property free and clear. And most of my clients don't own properties free and clear. They have existing debt against the property. And they've got to maintain the property and keep it free and clear during the entire term of their lease option. Now, this is just a 3-year lease option. You don't get any of these benefits if it's more than 3 years. Now, it doesn't apply to a lien that's placed on the property because of the purchaser. And it doesn't apply if it's placed on the property by the seller prior to the execution of the contract in exchange for a loan that is only used to purchase the property, a purchase money loan. But there's a big if. The big if is the seller not later than the third day before the date the contract is executed, you got to notify the purchaser the name, the address, the loan number, the monthly payments, and if the seller fails to make the payments, then the lien holder can collect the note by foreclosing and selling the property at a foreclosure sale. You've got to notify them, and here's the real problem. Well, this is just one of the problems. At no time will the amount of the lien be greater than the amount of the total outstanding balance that's owed by the purchaser. And the lien holder's loan can't prohibit the property from being encumbered by an executory contract. Well, let me just tell you, virtually every institutional lender has a due on sale clause in their loan. Anybody not know what a due on sale clause is? I'm happy to explain it. Don't be ashamed, okay? Very quickly, a due on sale clause is a provision in a loan that says if the borrower decides to sell the property that they bought, they've got to get the permission of the lender in writing. If they don't get that permission in writing, the lender can call the note immediately due. So it's called a due on sale clause, okay? And then the lender has to consent to verify the status of the loan. So you're going to have to go to the lender and get them to agree to verify on the request of the purchaser and to accept payments directly from the purchaser. So the point is, you're going to be throwing this right in the square in the face of the lender if you're going to try to do one of these transactions. I actually have a client that had sort of a captive lender, and he set up a system whereby he could get the loan, and the lender would not prohibit the property from being encumbered by an executory contract, and he would get them to verify the status of the loan. So there are hoops that you can jump through. The question is, can you get that done to get a 3-year lease with an option? And then there are so many other problems even trying that you're going to see that this is not necessarily what you want to do even if you can. They have to give monthly statements. They have to notify them if they've been sent a notice of default. I'm just going to go through these very quickly. The purchaser, this is one of the problems. Your buyer might decide not to pay you. And when you don't have the money to pay your loan, then the purchaser can go pay the underlying lender and get 150% credit of any amount paid. So here they can default on paying to you and then go pay the lender directly and effectively get a credit for 150% of all monies that they've paid, even though they didn't pay you. I don't think you typically want to put yourself in that position. It's a false, misleading, or deceptive trade practice to violate the section, and most importantly, it entitles the purchaser to cancel and rescind the executory contract and receive the return of all payments of any kind made to the seller under the contract, including reimbursements to any taxing authority or the value of any improvements that were made by the purchaser. So, anybody ready to go out and do a lease with an option under present circumstances? The odds are not good in Texas. You don't want to enter into a lease with an option of more than 180 days. And by the way, we constantly get questions about, well, what if we commit to doing just a 180-day lease option and we'll just renew it every 6 months? We'll renew it. I don't think that's a problem. You just can't commit or agree that you're going to renew it every 6 months. You can do a 6-month deal, and then after it's over, they don't exercise their option. Then you can say, okay, well, I'll be willing to do another one, but you can't commit to doing the next one in advance. Does that make sense? To commit to doing more than one is to do it for longer than 180 days. This is how you have to, what you have to do if you want to enforce the remedy of rescission or forfeiture, and I'm not going to go through that. It's not terribly important. Now, here's the other problem that you got. You can't charge a late fee if you do one of these transactions. You can't charge an option fee that's forfeitable. You can't, none of these provisions can be waived by law.